Clarence Thomas is, of course, not alone in his commitment to the Declaration of Independence. As every 4th of July makes clear, most Americans agree with him. However, what makes Thomas without question the 21st century's most important voice on the Declaration is the official position he occupies in the American regime, one of 9 members of the nation's highest court. Thomas, in short, has the power to do something about effectuating the individual rights principles of the Declaration. His civil rights opinions and votes demonstrate that he has been more than willing to do so during his tenure on the court, and I will briefly describe a couple of those to you. In 1995's Missouri versus Jenkins, for example, Thomas became the first Supreme Court justice to directly criticize Brown v. Board of Education. Of course, he agreed with the result that state-sponsored segregation was unconstitutional. But he said that the court was wrong in 1954 to rely on disputable social science evidence to declare segregation unconstitutional, rather than, quote, invoking the constitutional principle that government must treat citizens as individuals and not as members of racial, ethnic, or religious groups. Thomas's conception of civil rights as an individual, not a group concern, also explains his approach to voting rights. In 1994, in Holder versus Hall, he wrote that racial groups shouldn't, quote, be conceived of largely as political interest groups, that African Americans don't all think alike, and that existing case law should be overturned to eliminate claims for proportional allocation of political power on the basis of race. And in Adirondack Constructors versus Pena, the 1995 government contracting case that called the constitutionality of affirmative action into serious question, and of course Thomas is most famous for his opposition to affirmative action. But in that case, Thomas invoked the Declaration of Independence as the rule of decision in his separate opinion. And this is what Justice Thomas wrote separately in that case. There can be no doubt that the paternalism that appears to lie at the heart of this affirmative action program is at war with the principle of inherent equality that underlies and infuses our Constitution. And then, instead of citing C. Brown v. Board or some other case, he says, C. Declaration of Independence.